Now from the skies, we move downwards to the legal issues of deep seabed mining. Our next panelist is Dr. Joanna DINGWALL. Dr. DINGWALL lectures on international law at the University of Glasgow. Her extensive writings on the law of the sea, especially on deep seabed mining, cultivated this year with the publication of her monograph, International Law and Corporate Actors in Deep Seabed Mining. Dr. Dingwall is also a lawyer to the Scottish Government, advising it in particular on public international law, including the law of the sea, legal aspects of offshore renewable energy industry, and protection of the marine environment. Dr. Dingwall, may I invite you to tell us how you see the present legal scenery of the deep seabed mining beyond national jurisdiction? You have the floor, please.
Thank you, and good afternoon from Glasgow. It is a pleasure and a privilege to be talking to you all today. I'd like to thank the Ministry of Foreign Affairs for hosting us, and the Korean Society of International Law and ICLS for organising this important event. Thank you also to Judge Kolodkin for the kind introduction. As he described, I lecture international law at the University of Glasgow, and I'm also a lawyer to the Scottish Government, where I advise on law of the sea matters, including offshore renewable energy and protection of the marine environment. Everything that I say today is my own personal opinion and does not represent the views of the Scottish Government. I'm delighted to have the opportunity to talk today about the impact of technology on law of the sea. As I will address, deep seabed mining beyond national jurisdiction is one key area where new technology is really having an impact in terms of both offering potential opportunities and posing significant challenges, particularly in environmental terms. I'd like to start by reflecting on the words of the Secretary General of the International Seabed Authority, Michael Lodge, who last year announced that the decade of deep sea exploration has begun. As Secretary General Lodge noted, with a projected global population of 8.6 billion in 2030, the world is looking to the deep ocean for renewable energy solutions to meet growing resource demands. Presently, deep seabed mining remains at the exploration stage. However, it is anticipated that exploitation may begin soon. Indeed, the clock is ticking. So last summer, Nauru triggered the so-called 2-year rule, and this gives the authority a countdown of 2 years to finalise the draft rules on exploitation. At the moment, the authority is working to an expedited schedule to finalise these rules by July 2030. Against this backdrop, I will focus today on 3 main points. So first of all, I will very briefly set out the scale of the deep seabed and its resources. Second, I will address the key parameters of the legal regime. And then I'm going to finish by giving a flavour of the emerging trends and challenges facing the legal regime. Okay, turning to my first point. What is the scale of the deep seabed? The deep seabed beyond national jurisdiction is known as the area. And on this image, it's shown in white. It's important to keep in mind that the area covers half of the Earth's surface. So by any reckoning, the remit of the ISA is substantial. As illustrated in this image here, the area is home to a range of resources, and these occur at various locations throughout the oceans. These resources are dominated by metallic minerals, typically at depths of around 5 kilometres. And to give some context, here are the 3 main resource types. So we've got polymetallic nodules, polymetallic sulfides, and in the top image, cobalt-rich ferromanganese crusts. Polymetallic nodules and cobalt-rich crusts are amongst the slowest forming substances on Earth and can take millions of years to form. In contrast, polymetallic sulfides tend to have a more volatile origin. They typically emanate from hydrothermal vents on mid-ocean ridges where tectonic plates meet, causing volcanic activity. So, for example, along the Mid-Atlantic Ridge. Significantly, due to advances in technology, for the very first time in history, we've reached a stage where it may be possible to extract these resources on a commercial scale. And this image here shows the kind of operations that might be involved. So this is the broader context in which the regime is operating and that we need to keep in mind. And that leads me to my second point. What are the key parameters of the legal regime? Many of you in the audience are very familiar with the intricacies of the deep seabed mining regime. To recap briefly here, I've included some key elements on the slide. The core of the regime is, of course, contained in UNCLOS Part 11 and Annex 3. It's based on the overriding fundamental principle that the deep seabed constitutes the common heritage of mankind. No state or commercial actor can unilaterally claim sovereignty over the area or its resources. Instead, we have one central body, the ISA, to regulate deep seabed mining on behalf of the international community as a whole. And to this end, the ISA operates a contract-based licensing system for exploration and ultimately exploitation of deep seabed resources. This is open to participation by UNCLOS state parties and their nationals, and ultimately the ISA's mining arm, the enterprise, once it becomes operational. Alongside marine environmental protection aspects, which are still being developed, there's also an emphasis on benefit sharing, including particular consideration for the interests and needs of developing states. One major challenge facing the regime is that it is incomplete. So, although the core of the regime is in UNCLOS, in practice, much of this was modified by the 1994 Implementation Agreement. UNCLOS and 1994 Agreement, they contain the key legal framework applicable to the area, but the authority has the duty to gradually develop a comprehensive mining code, a set of rules to govern the entire life cycle of deep seabed mining operations. So far, this is a work in progress, and I've included here on the slide the regulations that we have so far, all dealing with exploration in relation to the 3 mineral types currently regulated. However, the ISA is still drafting the rules for the exploitation activities and accompanying standards and guidelines. And here I have set out the overview of the gestation period so far for the draft exploitation regulations. And this started back in 2011. As I've mentioned, Nauru has now invoked the 2-year rule within the 1994 agreement, giving the authority until summer 2023 to finalise these rules. So to sum up, we have a legal regime spread across various instruments, UNCLOS, the 1994 agreement, and the developing mining code. It's underpinned by the fundamental notion of the common heritage of mankind, but the rules on exploitation are still in draft form. And this brings me to my final point and the main focus of this talk. How is all of this translating in practice? And what emerging trends and challenges can we identify for the operation of the legal regime? Well, in terms of trends in participation, despite the unfinished nature of the regime, commercial activities are pushing ahead. So far, the authority has granted a total of 31 exploration contracts to a mixture of states, state-controlled entities, and private corporate actors. As illustrated on this map, These here are the ISA contractors so far. And as we can see, they are conducting exploration activities right across the globe, including in the Indian Ocean, the Pacific, and the Atlantic. Under these contracts, the total area approved for exploration has reached nearly 1.5 million square kilometres. But to put that into perspective, although it's a tremendous area, that is still only 0.5% of the entire deep seabed beyond national jurisdiction, which is open to activities. Of the existing contractors, countries particularly active include Korea, China, Russia, Japan, and India. And then within Europe, Germany, France, and the UK. Most active so far in terms of the number of contracts granted have been Korea, China, and Russia. At the moment, these are the only 3 states in the world to hold contracts for all 3 types of minerals regulated, so nodules, sulfides, and cobalt-rich crusts. Interestingly, within this participation in the regime, 2 significant trends have emerged over the last decade. The first of these is the increasing involvement of private corporate actors within the regime. So under Article 153 of UNCLOS, corporate actors can apply to undertake mining activities if sponsored by their state of nationality or effective control. So under this provision, private corporations now hold over 20% of ISA mining contracts, and that's up from 0 as recently as the start of 2012. Specifically, as I've shown here on the screen, there are 5 corporate actors at the moment, and they hold 7 contracts between them, all for nodules exploration in the Clarion-Clipperton Fracture Zone in the Pacific Ocean. So UK Seabed Resources Limited, it's a UK corporation holding 2 contracts, but ultimately it's owned by the US defence giant Lockheed Martin. So as an interesting aside, by participating through its UK subsidiary, Lockheed Martin, a US national, has managed to successfully circumvent the fact that the US is not a party to UNCLOS and can't grant sponsorship to its own nationals. We also have the Canadian mining company Deep Green Metals, which has recently merged to form the metals company TMC. It holds 2 contracts through its subsidiaries in Pacific Island nations, Tonga and Nauru. The Belgian company Global Sea Mineral Resources, or GSR, has 1 contract. Ocean Minerals Singapore, OMS, also has 1 contract. OMS is majority owned by the Singaporean Keppel Corporation, with UK Seabed Resources Limited as a minority shareholder. And then finally, we have the newest contender who signed a contract with the ISA earlier this year in April, and that's the Jamaican company Blue Minerals Jamaica Limited. Following on from this, the second notable trend in commercial participation is what the ISA has termed a new way of doing business, whereby some forms of collaboration are emerging between Western companies and developing states. We can see this in some of the contracts I've already mentioned. So, for example, Deep Green, a Canadian company, holds contracts through subsidiaries in Nauru and Tonga. But also, some mining contracts are held directly by developing state enterprises, but are in fact being performed by Western companies through joint ventures. We see this with the Cook Islands Investment Corporation. That's a state-controlled corporation controlled by the Cook Islands. It has an ISA contract for nodules exploration, but in fact that's being performed by joint venture with the Belgian company GSR. Similarly, Kiribati has an ISA contract through a state enterprise, and it is in fact being conducted by a subsidiary of Deep Green. If we include these two contracts, it shows that private companies are currently conducting almost 30% of ISA contracts. One significant aspect of this in legal terms is that by partnering with developing states or routing their operations through these states, Western companies are gaining access to what is known as reserved areas within the UNCLOS regime. So broadly speaking, the deep seabed mining regime provides for this system of reserved areas whereby prospective miners must propose 2 mining sites of equal value. The ISA will allocate one site to the miner while reserving the other for activity by developing states or potentially the enterprise. So what does this mean for the legal regime? Well, on the one hand, this moves the system further away from the original UNCLOS vision of fostering active participation on the ground by developing states within deep seabed mining and encouraging transfer of technology. However, in practical terms, from a common heritage perspective, some would argue that the only realistic option for developing states wishing to participate in mining but lacking in technical expertise and financial resources may be to partner with private actors. And that is certainly what some of the developing states involved have argued. The impact of this in the longer term, including on the common heritage of mankind, remains to be seen. So those are the two key trends that we're seeing in terms of participation in the regime. There are also a number of significant challenges facing the regime right now. And this is reflected in the increasing attention that deep seabed mining is gaining within wider society. The media stories I've included here on the screen, these are just some examples from the last few months alone. Arguably, the two biggest challenges for the regime are in finding a way to deliver robust protection for the marine environment, while also developing an appropriate mechanism for benefit sharing, particularly in financial terms. And these are two matters that the ISA is grappling with just now in developing the exploitation regulations. Firstly, in relation to marine environmental protection, we are seeing increasing concerns from many states around the world, the scientific community, NGOs and civil society, including many calls for a moratorium on deep seabed mining. The deep seabed is home to a vast array of species, both known and unknown, including a wealth of BBNJ. The oceans also play a critical role in global sustainability, for example, in regulating temperature and greenhouse gas emissions. There are grave fears that deep seabed mining could have a potentially devastating impact on the marine environment. However, perhaps paradoxically, proponents of mining are arguing that one of their key drivers is to obtain raw materials for green energy technology. Only 2 weeks ago, here in Glasgow, a mile down the road from where I'm speaking to you just now, the international community reached agreement at COP26 to work towards lowering carbon emissions. This move to curb carbon emissions is leading to an unprecedented demand for critical minerals. Some experts argue that deep seabed minerals could provide a key source of metals for the energy transition, so such as copper, nickel, cobalt, and rare earth elements. So what we have then is this very real tension between, on the one hand, concerns for the marine environment, and on the other, the management of commercial interests and in exploiting and obtaining critical raw materials. This is a tension which the legal regime needs to address carefully in order to preserve the marine environment while potentially allowing a certain amount of commercial activities. And secondly, and finally, in terms of benefit sharing, one particularly notable aspect of the regime is its radical system for the distribution of mining profits. Once commercial production begins, miners will be obliged to make direct payments to the authority. These payments are then to be shared equitably on a non-discriminatory basis through a mechanism which the ISA is in the process of devising. And it needs to take particular consideration the needs and interests of developing states in doing so. At the moment, we're seeing significant tensions in the negotiation of appropriate rules for the payment mechanism. And this also includes environmental aspects and the argument that no amount of profits could make up for the damage that deep seabed mining may cause to the ecosystem services and natural capital of the oceans. So to sum up, my conclusion is that there are no easy answers to these challenges. The next year or so will be critical in determining the future of the deep seabed mining regime and striving to deliver workable rules for exploitation that safeguard the marine environment while delivering sufficient benefit sharing aspects. So with that final thought, that concludes my presentation. Thank you very much for listening, and I will now hand back to our moderator, Judge Kolodkin.
Thank you very much, Dr. Dingwall.